I'm Eric Burgmaier. We've talked on the phone a couple of times on at least one or two deals, and I appreciate your method, your character, your cadence. The way you helped us with the few client deals was really extraordinary. You're the kind of attorney that I like to work with because you're not seeming to create roadblocks unnecessarily. And not saying at all that you'd rubber stamp whatever we put in front of you either. I see you as a gentleman that wants to help recognize that a deal is meant to be, could be done if it should be done, and you help that process. And we've worked with other attorneys that have just created roadblocks so many times,
Yeah.
and to some degree, really unnecessarily. And so when I was told that you wanted to do this with us, I was really excited about that because personally, I did want to thank you for the few times you worked with us on some of the deals we've been on, that you've just been a great professional to work with.
Well,
And
thank you. I appreciate that. And it's been good working with you guys as brokers. You do a good job of marrying up clients, it looks like, buyers and sellers, but also getting terms that are that work and the structure so that the lawyers can put the deal together. So and you guys keep on us to make sure we're staying on it. So
that's Kelly.
Kelly does a good job of that because we have at any one time 4 or 5 transactions going on, and so we're busy, and sometimes things take a pace less than what the client or what Kelly are wanting. So I appreciate the encouragement.
Perfect. And so with that, why don't you tell us a little bit about who you are and your law firm in a few minutes or less?
Okay. Well, my name is Tom Briones. Our firm is Briones Business Law Consulting. We formed in 2011, excuse me, and the purpose of the firm was to solely represent locally owned businesses, and so that's our focus. Our hope is to transform Albuquerque and New Mexico through small business or locally owned business, because it's our belief that it's local business owners that care about the community, they invest in their people and their companies, and they give back to the community. So if they're successful, that's how we have all boats rise. So that's our passion, and that's why we're here. We do a lot of buying and selling of businesses. We probably do 20 or 30 acquisitions or sales a year for clients of all sorts. And so, in fact, I went back to law school for an additional 2 years to get an LLM in advanced business transactions. So we love doing that. That's our Super Bowl Sunday, anytime we can do a transaction. But we help clients with employment issues, contracts, regulatory efficiencies for their organization, et cetera.
Perfect. And it's similar on our side. I guess I'm hearing potentially in some degree you could be like their outsourced legal staff to some degree, right? Because a lot of small businesses can't afford to have a full-time attorney, and they can't afford to have a full-time CFO. So where you may provide that role of part-time or as needed legal counsel for the small business, maybe we do a little bit of the same on the CFO side.
Oh, yeah. Yeah, I think so, because we do have a program where we act as the general counsel for clients for a monthly flat fee. That way, they don't have to worry about the hourly cost. How much is it going to cost to seek the advice or get a letter written or something, or get a contract drafted up. It's built into the program, and they just start using us differently. They start using us more proactively because they're already paying us. So it's, instead of us Googling it or using AI to try to figure this out, why don't we just turn it over to our attorney, the professionals, and let them handle it? And it just changes the dynamic of the relationship.
I like that a lot because the term you use, being proactive, and it's so many times, we sometimes we get involved in HR issues that, gee whiz, if we got in front of those earlier with the client, if they had just talked to us earlier, we could have avoided something. And a lot of times the same, just on legal issues. And if things are going good, people don't think like, I need to call my attorney. But you probably should be calling your attorney every once in a while anyway, just to check in and say, hey, anything I should be aware of? You want to start off with maybe talking a little bit about the Corporate Transparency Act and what your thoughts
Sure.
are on what small businesses need to be doing right now if they haven't started?
There have been three big things that have happened this year. You've had the Corporate Transparency Act that was started, that was passed by Congress and started January 1st of this year. And then there's the FTC ruling that was released regarding non-competes. And then our Supreme Court just issued a ruling, the US Supreme Court about a month or two ago, affecting buy-sell agreements supported by life insurance. So those are really earth-shaking for us corporate lawyers and also accountants, I'm sure, because it's changing how we've planned for businesses to do business in a lot of ways. So let's talk about the Corporate Transparency Act. It is an act that is required for owners of certain businesses to file with the federal government through Fincen, who the beneficial owners or controlling people of a company are. Fincen is a federal agency that really monitors money transfers. They're mostly concerned about drug laundering, illegal money laundering, and illegal activities like that. So that's the purpose of the act, is to be able to understand, because for those of you who do open businesses understand, especially in New Mexico, there is a way to file for an LLC in which, to the outside public's eye, they have no idea who the owners or the parties are behind that company. And really, it can be quite secretive, especially if you have LLCs stacked on each other, which are perfectly legal. You know, if you have a holding company and other companies below it, you may have a LLC owned by an LLC owned by a trust, all perfectly having legal explanations. But it also, by some people, it has been exploited to try to hide who the owners are of a company. The regulation does say that if you are an existing LLC or company that falls in the category that has to file, you have, if you existed before January 1st, you have until December 31st of this year to file. But if you are a new company this year that's required to file, if you form this year, like if you form an LLC this month, you have 90 days to file. And if you fail to do so, you are subject to some pretty substantial penalties by the federal government. It's starting in 2025, that gets shortened to 30 days. There are 23 exemptions to people who have to file, but they fall in the arena of nonprofits, government entities, banking, financial institutions who are already registered with FinCEN. But if you're a small mom and pop operation, or if you have some real estate, you will have to file if you have 25% ownership or more, or you have control of the company. So you can't get away with putting it down to 24%, but you control the company, you'll still have to file.
The vast majority of the clients we work with are going to be sole owner operators of an S corp, whether it's a dental practice, medical practice, a small construction practice, and then with their spouse, they may own the real estate in a separate LLC. Those folks will likely be 100% required to file the reports.
Yes. And some people have what I call shelf LLCs, these no asset LLCs that they have at the ready, or it used to have an asset, but they sold the asset, but they're keeping it alive for purposes of future business activity.
Yeah.
And it is okay to keep it, and you won't have any filing requirements if it is in inactive status.
Okay.
But that does force you to actually file some documents with the IRS, the New Mexico Tax and Rev, and the Secretary of State's office, letting them know that it's in inactive status, and then you just can't start up business again. Then you have to inform those same agencies that you're now active again. But it is possible to keep them and
Yeah,
not have to report, provided you've put it in inactive status.
I mean, this is not a do-it-yourself kind of thing.
Well, you're right about that. And to add another layer of complexity is the lawsuits that have been filed around the company challenging this law. There was a court in Alabama that did rule that this was unconstitutional, and it blocked the federal government from requiring this one business owner from filing. The problem is it was not a nationwide ban.
Hmm.
So it only applies to that one company. Other companies or other people have challenged it, but nothing has filtered up yet enough for direction from any court of appeals to tell us one way or the other. So what we've been advising our clients is the ones that were existing before January 1st, 2024, let's hold off until the fall before making the decision, because hopefully we might get some direction from a court somewhere. But if you organize or create a company this year, go ahead and file to be safe so you don't incur any penalties.
Personally, I'm a little fearful. I'm not going to remember how many teeny tiny LLCs I started over the years that I still may have open. I guess one, how do I approach that other than I guess go through boxes of old papers? But what can I do, and where am I at risk for me and other, because I do have other business owners in the same thing. We set this up, we think we're going to use it, then we forget about it.
One is, if you formed the LLC or corporation, you can search your name under the Secretary of State's office as an organizer or incorporator. And so that might be able to do it. Now, we organize a lot of clients. And so if you were to search your name, you may not be able to find it, because it's more likely our firm has the role of the organizer or incorporator for that business. But in that case, I would say it would fall upon the attorney or accounting firm who formed that company to let you know.
I'm wondering whether or not the intention of what this is supposed to do will be achieved, or is it just going to create more work for folks like you and me, another expenditure for a small business owner, and yet government's not going to get any more information than they currently have.
The biggest thing that worries me is the statute clearly says that if there's any changes, you have to update your filing. So if an owner leaves and is no longer an owner, you have to file with Fincen. If you dissolve the LLC and you're already filed with the Fincen, you have to update the filing. So it really becomes an enormous administrative burden to business, in my opinion. It's going to require a lot for them to remember, and quite honestly, it's going to fall to organizations like yours and mine to be on top of reminding clients, oh, we're dissolving this. We have this additional filing that needs to be done to inform them and help them get that done.
You're right, and this isn't just file and forget it one time thing, and I'm sure when a material event requires a reporting, it probably still has to be done in like 30 or 60 days, right? The government's not going to let you get till your tax filing deadline to notify them of a change in ownership. It has to happen within probably days, however many days of that change occurring now.
In my opinion, this is a huge net that's intended to catch a few small number of fish.
Yeah. Really, the next important thing we need to discuss, whatever's now happening with covenants not to compete. So can we just start? We throw the term around a lot, but can you bring us back to the basic legal terminology of what a covenant not to compete means, and if there's still applicability to it?
Yes. So a non-compete basically means that when you leave, well, during your employment, but most importantly, when you leave your employment with an employer, you're not allowed to enter into a market or start a business or be in a business that competes against your former employer. Uh, and they are legal and enforceable as of today. In New Mexico, there's California, they're not, and maybe a few other states, but in New Mexico, they are enforceable. By the way, they're not enforceable against doctors and they're not enforceable against lawyers unless they're owners of the company they're leaving. Then they can be subject to a non-compete. They do have some restrictions. They can only be, they have to be reasonable as to scope and duration. And so duration is time. So if you're an employee, a 1 or 2 year time frame might be reasonable under the circumstances. Certainly, like a 10-year one would not. There's a famous case out of I think it was Hobbs or Clovis where somebody sold their insurance agency. They were the biggest insurance agency in their region, and they got paid a lot and signed a 10-year non-compete. Court said that was reasonable because that person is still well known in the community and could re-enter the market and really hurt the seller, and they paid value for that non-compete. So they are enforceable. Non-competes tend to also have two other components that are independent of non-competes. Oh, before I get to that, I said scope and duration. Scope is where or in what activities. So if you are a plumber in Farmington and you restrict somebody from going out and opening a plumbing business and all you are is in Farmington, you could probably restrict that area. But you couldn't restrict them from going down to Carlsbad or Las Cruces if you're not doing business there.
Mm-hmm.
So it has to be reasonable. But if you work for Microsoft, worldwide might be a reasonable restriction.
Mm-hmm.
So it really depends on the circumstances. It also depends on who you are. If you are a cleaning person for the company or a receptionist, it is unlikely you have information that would be harmful to the former employer. And so it is unlikely, in my opinion, that a court would enforce a non-compete against, say, a receptionist. But they might against somebody who, like a really top-notch salesperson,
Mm-hmm.
might be able to restrict.
You say doctors, does that include dentists?
Of course.
I'd have to look at the definition again. I think it's primary healthcare provider. So I'd have to look at the statute again to I just don't recall independently if dentists fall into that category, but they might. Owners can always be restricted if they sell their business or they're interested in business. But the other thing is there's also components of non-solicitations and non-disclosures. So those are different. A non-disclosure means you cannot take information you learned from your former employer and use it at a different business or employment situation. So I can't take the price list or the vendor list pricing that I knew my former employer had with me so that I could underbid them at my new position. In the old days, the Rolodex was very valuable to the company. Sometimes companies will issue company phones with the specific purpose of taking those phones back so you don't keep the contacts that you've gained while you're there.
Mm.
So that's the non-disclosure. The non-solicitation could fall into non-solicitation of employees and non-solicitation of customers. So those would say you can't leave and take all my employees with you to a new employer, or you can't go to the new employer and then coax my employees to go with you, or you can't leave and take my customers with you or solicit them to leave. So there are times when non-solicitations and non-disclosures are so restrictive that they have the impact of being a non-compete. And if that's the case, then the courts will review it in light of a non-compete. The other thing that's important with non-competes or non-disclosures or non-solicitations is understanding you can bind employees with unemployment to those restrictions, because the consideration you're getting for those restrictions is the job you're giving them. So there's value exchanged, is the theory there. But if you're an owner and you decide, well, now I want these non-solicitations, non-competes in place, so I'm going to make everybody sign it in the business, that will not be enforceable unless you give them consideration for it. So they have to be paid value for it.
Mm-hmm.
And there's always a question of what is that? And that becomes a question for a court to decide. But if it's so low value, the court might say, well, this is not reasonable value that's been paid for this. Sometimes people don't want to do it for all employees, but they might do it for, like, if they're moving somebody up to a management position, well, the job opportunity may be contingent upon signing this non-disclosure, non-solicitation, et cetera. And the opportunity to get that position would be the consideration given for that non-compete, et cetera. But that's a lot of background to get into the FTC issuing a rule this year that banning almost all non-competes. There are a few situations where non-competes would still be enforceable. For one, if you're the owner of a business and you sell your ownership, you can be restricted to a non-compete. If you are a certain kind of employee, if you make more than 151,000 and you're in a position of policy making and your non-compete is in place before September 1st of this year, that non-compete can also be enforceable. You cannot restrict those employees after September 4th under the FTC rule. Non-competes under franchise agreements are still enforceable. So there are some situations where under the rule, you can still have non-competes, but for all other employment situations, the employee would no longer be subject to a non-compete. There was a ruling that came out this week from Judge Ada Brown in Texas that blocked the FTC rule for non-competes, claiming on the theory that it was this is restricted to the legislature and not a rulemaking body like the FTC. This is not a regulatory function. This is a function for Congress to decide, not the FTC. And so she has blocked the enforcement of the FTC rules. So we were planning on that rule going into effect the first day of September. That is not the case anymore. It is now the effect of the FTC ruling is now on hold until we get some decisions from some court of appeals, because at around the same time, there was a court in Pennsylvania that ruled that it was legal and enforceable, and that within the rulemaking authority of the FTC. So we have two courts that have conflicting decisions, which means it needs to get appealed to their various courts of appeals. If those courts of appeals don't agree, it will have to go to the Supreme Court. So it could be some time before we know whether or not this rule is going to actually go into effect, or what the rule may end up looking like if it does go into effect.
What would then be the time frame of something like this ultimately getting to the Supreme Court? Would it be like by next summer, or could it be a couple of summers from now? I guess it just depends, but this seems to be a really big deal.
It's a big deal. So it depends on the Court of Appeals right now, not the Supreme Court. It's the Court of Appeals from both circuits that cover Texas and Pennsylvania. Those circuits will decide whether or not they expedite a hearing, or they just put it on their normal docket. If it goes on their normal docket, we'll be lucky to get a decision from those courts late next year.
Okay.
From those Court of Appeals.
from a legal perspective, from how you practice, are you and other the the rest of the local community of attorneys kind of in this limbo? It's like, do we consult our clients today to say yes, continue to put these non-competes in, or can we not because the FTC said they're not enforceable, but maybe they are, but we don't know what may ultimately come. So what do we do now?
I don't know what's happening in the local bar with the other business attorneys. I think all of the local business attorneys were all so busy that we're not communicating with each other on this stuff. But the American Bar Association and different sector groups within of lawyer communities, we are studying this very closely, and we are reading articles all the time by experts in these areas on these opinions. But as of right now, it is likely that in New Mexico, court would find that it has been put on hold, the enforcement of it. But the reality is we won't know until somebody challenges it in a court here locally.
Here, okay.
Because Texas is not in our circuit, and neither is Pennsylvania. So the 10th Circuit has not, and no local courts have ruled on that yet. So as far as the local courts are concerned, it's probably in effect, except for Judge Brown did say that this is a nationwide ban. So it's definitely a limbo, and it needs to be discussed. But in my opinion, it is likely that the non-competes will continue to be enforced as is and unchanged until there's a court of appeals that rules on this.
We still believe, and it sounds like that's okay to still take this position, that upon sale, a covenant not to compete is still valid for the buyer and the seller, but I guess more so for the buyer to be able to enforce a covenant not to compete against the seller, because again, there's no more potential goodwill value if the seller doesn't sign a covenant, and you're a dentist buying a dental practice, and then the doc just opens up across the street. I mean, you wouldn't be able to sell businesses anymore. You wouldn't be able to sell your business to somebody else unless there is a covenant not to compete, unless you sell it for $1, I guess, because otherwise there's no more goodwill.
Well, and as far as the seller is concerned, the FTC rule does not impact them because they can still be restricted to a non-compete. But this is where it will happen is some employers have key employees that the buyers want to make sure are locked up with non-competes. So if you're buying an organization, you want to make sure that the key salespeople, or if you are an engineering firm or a manufacturer and you have some key people that have information or knowledge that you don't want going to a competitor, oftentimes it's a requirement of the transaction to make sure that those identified key employees are bound by a non-compete, and it will definitely impact those situations. That's what's in limbo.
A lot of times when we see a young dentist who's got that entrepreneurial spirit and saying, I'm ready to take this on my own. I'm ready to buy a practice. I'm ready to jump into this world, but I can't because I've signed an employment agreement, and I don't want some big corporate company to come after me. My thought was always, like, as you started this section with, that they're legal in New Mexico with the exception of doctors. Of course, lawyers, that only makes sense. Like, you guys are
but that's not by statute. It's because the Supreme Court has said that clients always have the right to choose their counsel. So
gotcha. If I'm a young dentist and I've just come out of school and I'm going to work for a regional corporate facility that happens to have a dental practice, or maybe 3 or 4 here in town, and I say yes, but then I have this employment and contract that goes a year, and we sign it, and now they're fearful. Well, I've signed this, and let's just say we're 3 years in. First couple of years have been great. I'm in my 3rd year now. I've paid off most of my student loan debt. I've honed my skills as a clinician. I see everything that this little DSO isn't doing right, and I think I can do it better. And there's a practice I'm interested in buying, but I just now signed my contract for the third year. If I sign this and commit for the year, but you don't give me anything extra for the benefit of signing for that, and I choose to leave, can they sue me for anything other than? And it's like, okay, they're not. I'm going to say they're not enforceable for that doc, because doctors are doctors regardless of what they practice, whether it's podiatry, dentistry, or any kind of general medicine. They're doctors, and they, in my opinion, will fall under this exception. And if I didn't get a sign-on bonus for that third year to sign that contract, I choose to leave. What's the risk?
What I would probably do if I was the attorney, if I represented the employer, is I would probably craft the agreement so that there are clawbacks. So, all right, we're giving you so much extra money to sign this agreement. We're giving you so much extra money or in benefits, or we're giving you, doing something, we're paying your student loans, whatever it is that's extra.
Mm-hmm.
I would categorize as, for incentive for signing this agreement. And as liquidated damages, I get to claw that back from you if you leave.
Okay. I don't know how often these young docs do this, but they probably should have somebody look at that employment agreement before they sign it.
Oh, yeah. That's your opportunity to negotiate your terms. People think, well, I'm so lucky to get this job, I need it, or, they feel weird about pushing back on certain terms. But I mean, I've got a situation with a client that he left a company along with some other people, and the former employer is going after all but the other employees because he sought counsel before he left. So he was able to leave without violating any restrictions. And we helped him negotiate his employment agreement with the new employer. And he got a deal different than everybody else. He was the only employee separate from the other employees to get this deal. He had extra protections in there, more money, better bonuses, etc. All because he negotiated his deal and had it reviewed by an attorney.
Very good. Plug for the attorney when they're on your side. Any closing thoughts on covenants not to compete?
I think the way it is now is it's business as usual. They are enforceable, and after September 1st, I believe they will continue to be enforced by New Mexico courts until we get further guidance. So if it's important to your business, certainly it is there. But if you fear that potentially the courts go a different direction and you're fearful that these non-competes you bound your employees up to are not going to be in effect, consult with a lawyer about what are some strategies that can be employed as an alternative to discourage employees from leaving your employment through good incentives and good employment situations, but also penalties if they do leave. I do have a question before we leave.
Yes, sir.
When it comes to your services, both as a broker, but also as an accounting firm, in my practice, we deal with a lot of accountants, and I get very frustrated with some accountants that are more glorified bookkeepers. They're not actively participating in their clients' businesses as far as advice, as far as consulting services about things that they consider. Is that something that you guys do for clients? So I can have that understanding for future clients of mine.
Yeah, so we've built this firm to be a combination of the traditional accounting and bookkeeping services that most small businesses need. And my role is more of a tax as well as a financial advisor to help my clients understand their financials and provide more business advice rather than a reclassification of expense from office supplies to dental supplies or whatever, those kind of things. So So, at this moment, why we're so busy at this point in the year, obviously tax season seems to go on forever, but more importantly, this is where we're doing our 6-month check-in with all of our monthly clients. Where are we year to date? What is your potential tax liability look like? What can we provide in terms of assistance to either mitigate that tax burden if we can, or otherwise prepare for it? Do we have cash in the bank to pay for that? If not, what are we going to do on a go forward? So, when I started in this business years and years and years ago, I had a client that really kind of a brilliant doctor and would always challenge me on what is the role of a bookkeeper? What is the role of an accountant? And he was trying to build a decent sized company. What's the role of the controller? What's the role of the CFO? And that always stuck with me is what are those different roles and where along the way do I personally fit in that? And my job today is to be that of the CFO. I allow the rest of the team to help prepare the financials so that I have good information that I can then interpret with my clients. And that's my job. And so I'm lucky to have a good team of accountants and bookkeepers that can get me ideally good financials. And when I look at them and something's wrong, that's where I go back to them and say, I don't agree with this. We need to fix that before I present. And then when I present, what is it that I'm working with on the client to, again, where we can mitigate tax liabilities. And more so, the questions a lot of times come up is, help me project out. What is it going to look like, 6 to 12 months down the road? Can I improve my bottom line? And how do I do that? Where do I do that? So that's where I spend more of my time. And that's really over the summers kind of where I go to work doing that. It's kind of like a pre-season 2024 tax season right now. It's a combination of tax prep as well as making sure they understand their financials.
Excellent. Well, I look forward to more opportunities in the future to work with you and your firm.
Perfect.